Recently, a friend of mine, Carolyn Elephant, who writes myshingle.com, talked about potential malpractice based on technology. In her presentations around the country, she has observed that a number of lawyers, particularly sole practitioners, fail to use technology to its fullest. In fact, she said many of them fail to use technology even to the slightest. They don't even have email accounts. When Carolyn and I had this conversation, she was really thinking in terms of the value of the law practice in terms of sale. But I wanted to bring in another context, because Carolyn is quite right. If you do not have systems, if you do not use technology well, the value of your practice is less than it would otherwise be. However, in the broader context, these very same lawyers generally are not worried about the sale of their practice because they think their practice has no value at all anyway, something with which I disagree, and that's subject matter for a different presentation and commentary. However, they may be committing malpractice, which is even worse. Rule 1.1 of the American Bar Association, Rules of Professional Conduct, call for the definition of competence. And although the rules of professional conduct for the American Bar Association currently make no reference to technology, I believe that that's still an element of consideration should somebody be accused of not being competent. And in fact, years ago, in one of the reporter's notes to the ABA rules, there was a reference to technology and being technologically proficient in comparison to other lawyers in the same practice area, in the same geographic area. It does not take a huge stretch of the imagination, however, even without being specific in its language, to think that any commission will review the context of the allegation in light of technology, among other factors. And in fact, let me quote to you from the Canadian Bar Association Code of Professional Conduct in Chapter 2 of the CBA's rules. They say, the lawyer should also develop and maintain a facility with advances in technology in areas in which the lawyer practices to maintain a level of competence that meets the standard reasonably expected of lawyers in similar practice circumstances. So one way or another, whether we refer to a specific statement in the Rule of Professional Conduct or not, technology and its use will be considered, or perhaps I should say, likely to be considered in any allegation of competence or incompetence. That is going to be one of the standards. So what are you doing in your practice area, in your practice, to use technology, to maintain your skills, to deliver more efficiently and effectively services to your clients as they expect? I don't think you need to be at the bleeding edge. I don't think you need to be at the leading edge. However, I do think that you have to be in the pack in the context of how you use technology in today's world. Thanks for joining us.